Hello, everybody. Thanks for attending this webinar, which is going to be about the new regime of class actions in France, which is a quite recent topic. And we hope it's going to give you some good insights at the end to know how to manage this and any potential upcoming risk that could occur with this potential new volume of litigation that could come up in some time. Next slide, please.
Hello, everybody. So presenting today, Pauline Pierce, myself. I'm head of the labor and employment practice in Paris, working for a number of years and very interested in this new topic, which is definitely going to change the landscape of France. And you were thinking here that France was already very complicated. We're adding an additional layer for you today.
And I'm John Sebastian, so working within the LNE team in Paris with Pauline on lots of topics and very often on litigation and not to say mass litigations, but yeah, quite a lot, which is one of the reasons why it seemed interesting to go down this topic for you. If you could go to the next slide for me to run through the housekeeping topics. So just for you to know, so you're going to be all in the listen-only mode, okay, during the session. You have, of course, a Q&A box where you can put all your questions if you have some. What we would be willing to do is to run through these at the end of the session in order to ensure that what we're going to say to you is going to be fluid enough and enable everybody to stay with us. And we'll do our best. And of course, no worry if maybe something was missed, something we would like to review, to see again, to hear again. The session is going to be sent, the slides are going to be sent, and of course, you'll receive a link for the recording of this session. And I hope you will be enjoying it. So maybe you can go to the next slide and to see what we're going to be covering. So this is what we want to do today. It's going to be very practical, give you some backgrounds on legislation, of course, some very concrete examples on what needs to be done, not to be done, or how to anticipate. The purpose is for you to understand what it's going to be aware of what is going to happen, maybe have also a better knowledge of this this regime, which used to be complex but is a little less now, and have in mind the concrete examples, the exposures, the topics which are going to be shared with you, including those around the upcoming Pay Transparency Directive, not yet implemented in France, but which should be soon. So, of course, it seems quite important to start with the new French legal landscape, which is the next slide. At a start, very simply, so what is a class action in France? It's quite close and quite similar to, I would say, what exists in the US. Of course, it's different, but the idea and the principle is that unions or associations take legal actions for a group of individuals or a group of legal entities, but it's not going to be our concern because we're going to stay focused on employment law. A group of individuals who are represented by unions or associations, approved, not approved, and who want to litigate against an employer to have a situation of potential breach in law to seize or to get damages to indemnify them for the prejudice they would be suffering because of such a breach. The two are possible. And this law is really a turning point in what we do have in France, because, of course, class actions already existed since 2014 in France, but they were more focused on other topics than employment law. And when I would say employment law entered into the scope of class actions, it was very focused on a very, very small scope of topics, which I'm going to cover after. But mainly we had since then, so since 2016, not more than 10 class actions in employment law because of the complexity of the legislation, because of contradictions between legislations and our codes and laws. And as you see, the scope was very limited to discrimination, but only discrimination upon hiring, for internships or for access to training, and also in data privacy matters, but nothing more. And globally, since then, those class actions have not been closed yet because no decision is rendered yet. So maybe you could move now on the next slide to explore how and why the scope of this new legislation is broader. So, as I said before, it was focused on very small topics. Now, the key thing, which is totally unbelievable, I would say, is that class actions can be brought now for any breach to the labor code, which means that any topic in the labor code which is not complied with will potentially be a reason to have a litigation and will potentially give exposure to a class action. Two ways also to act will exist for class actions now. Seizing the breach, which will mean that a litigation will be brought in front of a court to have an employer seize the breach, which will mean that he will have to be compliant if he's not, after a court decision will be rendered. Or alternatively, being compensated, having the individuals who are part of a class action compensated for the breaches committed by an employer. So this will have potentially severe implications, especially because of the increased scope, which can cover, well, it will be more covered afterwards, but there are, I mean, labor code is quite voluminous. And as you know, our legislation is complex and anything can potentially be damageable. And this gives, of course, significant exposure and significant risk for your operations that you might have in France. And you will need to be globally aware of what can happen on those aspects. I would say the most also complex and big moving forward on this is the new initiators of class actions, on which I will spend maybe a little bit more time because this is our next slide. And this is something which globally is the key thing to be aware of, to know how to behave and how to act afterwards. So before, okay, in class actions, trade unions already had the right to act, but as I said, on the very limited scope of actions. Trade unions in France are of course present in some companies, but they are also present at sector level, and they are also present at national level. So of course, unionized companies who have trade unions representatives within their headcounts, okay, are potentially have the capacity to act and to trigger a class action, okay? But it could be limited to a company. But if unions at sector level were to act, they could potentially act on several companies. In case of breach of employment law, the problem, if I can say that is a problem, the problem is that the unions can do this without any limitation and on the two course of actions, which is having a breach to seize and acting to obtain a compensation for the companies, for the their individuals and the employees they will represent in terms of breach. So of course, trade unions will be even more now, and especially in a unionized company, in a powerful situation if they identify or not breaches within the entities where they work, and also within entities where they have some affiliates. Besides those trade unions, you can also have, so this one is not new, but needs to be known, approved associations, charities, who need to meet some conditions, which we'll not be detailing here, but approved associations who are to be listed on a decree, which will say this association can act on this topic, and identify like this, I would say, key associations which have the right to trigger class actions. And you also now have associations which are not approved. So it can be globally any association that is willing to, I would say, defend the interest of some individuals employed in companies. They, of course, need to be existing for at least 2 years. Reason why impact, in my view, is not going to be immediate on this. We have the time to act to avoid as much as possible facing those class actions to come up. But those associations will have 2 years to act, and their action will be also limited. They will be able to trigger class action to obtain the cease of a breach of the employer. They do not have the possibility to litigate to obtain damages, but they have the possibility to litigate to end the breach, which is, at the end of the day, key because it can be done quite quickly as an action as far as a breach in the employment law will be identified. There will, of course, be the time of court, which will be long, but it therefore gives more stakeholders who can take class actions, so more exposures to companies, which will have to care, of course, of the trade unions, but not only. And besides those type of actions, so have a breach to cease or obtain indemnification for prejudice suffered, there is also the possibility for the public ministry, which we have called the prosecutor here, to also trigger a class action in case of criminal issue, which is possible. So we're not necessarily talking about work accident or stuff, but typically in terms of business immigration, you have lots of criminal implications. In terms of bullying, harassment, you can also have criminal implications. So now prosecutors will also have the right to act, again, as for the associations which are not approved, able to act to have a breach ceasing. All those actors can also act individually. One union will be grouping several employees and try to obtain cease of a breach or indemnification in front of court. But they can also group together. Wherever in a company, we could also imagine through several companies if there are similar breaches committed by several employers of the same nature, even if employees are not all of the same company. And the question of financing seems also important because has been decided to adopt something which is similar to what exists in the US, which is the third-party funding. So unions can represent individuals who are not their affiliates or their members, and they can also raise funds to trigger class actions. Of course, there are restrictions. The funders should not be conflicted. It should not be practices of potential competitors of a company who is potentially at risk of a class action. But it seems quite important to be aware of this way of funding because it even more gives concrete implications and concrete accomplishment of those class actions, which is going to be made possible by this third-party funding, and which will, of course, require, when it will arrive, to always look at the funders to ensure that there is no conflict and that the purpose of the funders of a class action is not to prejudice or damage a company's situation because of a breach to the French code. Of course, this is the way you would trigger class actions. which is known and who can do it. But as you know, we have Works Council in France. We are keen to have a social dialogue and ensure that there are conversation and discussions with internal stakeholders. Reason why this is not new but needs to be known for several reasons. As soon as there is a breach, okay, of course, it is not possible to trigger immediately a class action. First thing will be for the actor to inform the employer that there is a breach and that the employer must put an end to this breach. Okay. As soon as this will have been received, which can happen, it is not a formal warning, so it can be brought. Globally, there are no details in law, but it could be brought by any means because it is not a formal notice. But employer needs to be made aware that there potentially is a breach that would trigger a class action, and the employer must respond to this and share the information with the social and economic committee of such threat, and also share the information with the trade unions if, of course, the company is unionized. And once this will have been done, this type of preliminary step, then there will be somehow a game of discussion and negotiation with the social economic committee, the trade unions, the employees, to see how we can seize the breach which has been raised as a potential class action trigger. During this time, it will be, of course, possible to have discussion, to seize the breach, potentially to find a way to organize the implementation of the compliance. But if no action is taken, and if the breach continues, if people do not agree, then it will be the time of the class action. And here, of course, at the time of the class action, it will be in court. There will be, of course, possibility to have mediations if the judge was to order a mediation to potentially agree. But mainly, based on law, if you discuss internally within 6 months, if you prepare, you could potentially avoid having issues on class action. And I think I'm going to leave it now to Pauline to go into more concrete details on what topics could be the one faced in case which could trigger class action.
Thank you, everybody. Yes, the reason we think this topic is crucial, really, for employers in France is that it is going to change the landscape of litigation risk, and it commands for a different approach, which is more on the compliance side. And what we thought would be interesting for you to hear about is eventually the concrete examples which we've thought about, which could eventually trigger significant liability for employers. They're classic themes that are developed usually in French litigation. The number one of them being overtime. As you know, we have a very complex working time regulations with different categories of employees. We have the 35-hour work week employees. We have the forfait jour, which are the what the US would call, or even the UK would call, exempt employees, which still have very stringent rules to monitor their working time. Before we could monetize the risk, we could see it on an individual case-by-case basis in the context of terminations. Today, that landscape is changing because, as Jean-Sébastien explained, either an association, so an NGO, or unions, which is the most likely case in our employment themes, are likely to take upon a notion. And when they notice a large number of employees who are either regularly working overtime, for example, in smaller companies where it's hard to monitor work time, or where vacations are not taken, or where there is no time recording of work time, or various sort of mismanagement or oversight from the employers. It's no longer the case that each employee has to individually think about how much money they could make. The union could step forward and introduce a class action and take action to obtain rectification of the system, and of course payment of overtime, which is, in our view, one of the most significantly expensive type of litigation which you can have in France. So point of attention, how am I managing working time? How am I controlling working time? And it is not because I don't have unions that the risk of class action on overtime will not materialize, because as Jean-Sébastien explained, you don't need to have unions in the workplace for the unions to consider a topic of interest and to threaten employers. This could also expand, for example, to remote work rules. Today, it is, of course, still pretty, much first-hand issue. Many employees work either hybrid, between workplace and home, or completely from home. And this gives rise to some complaints today regarding teleworking policies, where, for example, they would consider, always tied to working time, that they had no right to disconnect, or that there's no disconnection policy, or that they're not paid the adequate indemnification. And people are isolated in a remote work configuration, and so it's easier for them to regroup and take action together to ask for remediation of the policies or practices in the workplace. So those are two, we believe, very palatable and immediate compliance issues, which are going to draw the attentions of unions because they're easy to demonstrate, and they are most often it's really hard for employers to comply. So it's a major point of focus and attention in this new landscape. We also have a second theme, which we hear a lot about today, which are tied to health and safety obligation. So of course, we have the hazardous working conditions or toxic substance. We have the professional sickness, asbestos exposure, which could give rise to class actions, and that doesn't look good. So it's possible for unions to seek immediate cessation of danger, and of course compensation for workers that would be exposed to toxic materials. So if you do have a history of claims in this regard, audit and thorough analysis of what could be preemptively done to have a log of actions that would be taken is something that would be very useful. I would also say, and that's probably it's probably a case that really differs from what you would have if you're from the UK or from the US in terms of audience, is our class actions that are now going to be possible for moral or sexual harassment. We had a very famous case in 2008, which really changed, confirmed in 2022, which changed the way we treat moral harassment in France, which is also a quite of a important topic, which you probably have heard of if you've worked with French or in France, with French employees or in France. It's called the France Télécom case, where for the first time the courts and legal French courts recognized systemic moral harassment. Now, this is of interest. Why? Because the context of the case is that between 2006 and 2009, that Orange, our telecom company, decided to implement massive restructuring, which was planned at cutting jobs. And what did they do? They forced mobility. They reallocated tasks, and that gave rise, in this specific context, to pressure to move, and so forced mobility, some social isolation with the extensive use of remote working, excessive pressure to push people out, and dozens of employees attempted or committed suicide, and those were recorded. And the outcome was that the CEO and the head of HR of this very big French company were criminally convicted, and the courts recognized that they were that they had organized an institutional moral harassment environment and were collectively responsible for the situation of the employees, and notably the attempted or the suicides. Now, I'm talking about this case because since there is this institutionalized risk, it is also an area of focus of compliance where we would consider that it's important to prepare for potential widespread moral harassment or sexual harassment cases. How would that materialize, for example? You would notice several employees that take repeated sick leave or report degraded management or report unrealistic targets or intrusive surveillance, for example. The Works Council, or CSE, confirms that they are in agreement with those complaints and the recurrent abusive, I would use it loosely, managerial behavior. And what could happen is that a union would launch an action to have toxic workplace climate recognized and ask for compensation for the anxiety, psychological harm, and mandatory reforms of the management methods. This, of course, could apply to the same to sexual harassment cases. So those are concrete examples of what we can foresee in the near future, which would need to be prepared. And I'm going to ask for the next slide, where our advice, our practical advice, is focus on compliance. Taking, for example, harassment as a concrete example, what you need to keep in mind is that proactive prevention on the topics which we've mentioned, for example, but of course it's all other topics because it's all violations of the labor code, but those specifically that we've mentioned and identified as key factors. Prevention, compliance is a critical shield against those class actions. For example, for harassment or for hygiene and safety, make sure that your unique documentation, DUERP in French, is updated. Make sure that the procedures for the safeguard of employees are visible to all employees. Make sure that you implement training of all managers, of HR, to detect weak signals, for example, to detect discomfort on the workplace. Not, of course, workplace isn't supposed to be an ongoing party, but just detect, for example, if there's recurrent abuse or use of sick leave, just to notice that there's a pattern and take the matter at hand. Communication, also, foster a psychologically safe climate and promote clear reporting channels. On a side note, every time we've had massive moral harassment claims, there has been a view that reporting channels were not necessarily very clear or not necessarily very present, and that is a good way to diffuse moral harassment claims. So that's a point of focus of interest and compliance that I would insist on. Thorough documentation is the proof of diligence. So once again, track working time, maintain logbooks of any alerts, archive investigations, archive work logs, make sure you keep track of employees taking their vacation or their rest days if they're exempt employees. Make sure that you keep detailed records of conversation which HR and Works Council have on the topics which could raise concern. and to that effect, make sure that your Works Council is compliant and maintains minutes and keeps minutes and publishes minutes of every single meeting which you have with them, because they're supposed to do that, and that is important evidence in the cases that we mentioned. And the burden of proof is always going to be on the, well, mostly going to be on the employer. So all these documentation, logs, and preparation and work for, audits and compliance are necessarily going to be useful to actively and effectively defend class actions. If you receive a formal notice of a complaint, make sure that you provide a written response in the 30 days following receiving this this complaint. Be prepared to conduct flash audits, either internally or with HR, or if you have an investigation committee. And call meetings of the Works Council to discuss the topic and see how you can proactively nip the issue in the bud if at all possible. And all that will prove satisfactory sort of compliance steps, which will be very useful at the level of our lower labor courts, because they really look into the good efforts and good faith of employers. I don't know if there are any questions, Jean-Sébastien. Sorry, I'm on the screens. No questions. Okay. So moving on to what we a hot topic, which is also for us potentially a source in the near future, not yet because the directive hasn't been transposed, but of very probable use by the unions of class actions. As you know, there is a European directive which will, on pay transparency, which will need to be transposed into our French national legislation by June 2026, and it will concern in the first hand, it will concern companies for more than 100 employees. The transparency topics are that employers will be required to disclose salary. Employees can request data and explanation. You can no longer ask candidates about what pay they expect, and you're supposed to publish the range of pay which you offer per category of job. And the employers have to show that they comply, because they have to issue a report. And if there's a gender pay gap of more than 5%, active and effective corrective action is absolutely mandatory. And that is where we see potential risk here, because of course unions could use the new class action mechanism to challenge systemic pay discrimination in their view, demonstrate that non-disclosed pay gaps affect several individuals, and issue collective litigation to obtain global bonus payments or rectification of salary gaps. And that is going to be very public. So it's something that is going to have a high impact on reputational risk, because it's going to be completely in the spotlight as of 2026, because it's going to be a massive sort of revolution in the remuneration environment. So you want to think ahead on these topics to avoid, potential mass action and bad publicity and reputational risk, of course. The directive for the pay discrimination, the directive will do, the class actions would allow the courts to order cessation, so end of discriminatory pay structure, to repair the pay gaps between the affected groups, and that could be very expensive. and of course to obtain data, to disclose data on the criteria used, the average pay per category, the criterias that were defined to determine the pay and the various remuneration packages and schemes within the workplace. So the pay transparency directive significantly deepens the right to pay information and anti-discrimination enforcement. And the evolving class action framework will provide the judicial vehicle for unions or associations to effectively seek the application of this European directive, which wasn't the case until today. So it gives really a stronger a much stronger impact to this directive for the French legal system, and that's really all that I would say regarding the impact of the pay transparency on class actions and the upcoming litigation, which could ensure. So, as I have said, the major risk for employers are mass litigation risk. What you could contain when you had a contentious dismissal to 1 or 2 cases is definitely not going to be contained anymore. It's not necessarily going to occur at the time of dismissal, but could occur at any time during the contract, could give rise to significant damage awards, which is not typical today of our French court organization. Litigation is not as expensive as it is in the US. I know for sure in the UK, probably it could change that. So I would be on the lookout. And of course, we'll give lots more media traction to cases, because when it's collective, it's much more interested to have reporting, and what was not very public and what could go under the radar is no longer going to be the case. If if you have a brand to defend, or if your company attracts lots of public eye, this will be an additional issue to tackle. And this concludes the presentation on this new class action. And we'd love to take questions if you have any, or comments, to keep this discussion interactive, if you have any. Now, I don't see the questions on the panel, but maybe. Oh.
Concerning, just to add to the public, until you have questions on the public aspect, this is indeed important, because all initiators of class actions will have to, there will be a public list which will register all class actions that will be ongoing. So it's quite
easy to access.
Right, exactly. And also keep in mind that class actions will not necessarily, if I may, not necessarily cease with the litigation, because as soon as there's going to be a decision rendered by a court, normally the court will have the right to give a time frame for other potential individuals to join the class action and potentially claim for what would have been obtained. So the litigation in itself will not end the type of individuals who could potentially claim through the group class actions. So all this is really important, I think, to keep in mind, because it's going to be very impactful. Any questions?
No questions. Well, thank you everybody for listening in to this webinar. We hope you found some useful information. We're happy to help if you have any further questions, or want to, think about audits and compliance and steps to be actively taken to make sure that it doesn't shift into a new French employment law nightmare. We're happy to help.